It's a great honor for me to be here this evening. Excellency, thank you for your remarks. And Dr. Huck, thank you for inviting me. I'm grateful to be here. And it's good timing to be here for several reasons. First of all, we've heard a bit about what happened in Paris, and that was, generally speaking, a very positive development at the international levels, particularly for those of us who are concerned about the issue of loss and damage and the funding of how to deal with the loss and damage issue, a very critical matter. Much of what happened in Paris on this issue is, in fact, due to leadership from countries like Bangladesh and G77 and LDCs who have, in turn, been guided by leaders on this issue, like Dr. Huck and Hafiz Khan, who's in the room. So now is the important time to bring forward innovative approaches, both to preventing, to the extent possible, loss and damage, and also to provide innovative mechanisms, to provide financing to overcome the effects of loss and damage. I feel very fortunate to be here at this point in time and to have the opportunity, I hope, to meet some of you. I already had a brief chance to meet a few of you. I hope I'll have more of that, because I want to get a better on-the-ground appreciation of some of the things that this country is going through because of climate change. It's one thing to write about it, but it's another thing to experience it, and you are the experts in that regard, unfortunately. Another reason why the timing is good is because, as the ambassador said, I'm Canadian, Canada's back, and we hope that we can contribute to various aspects of trying to help on the climate change issue. So it's let me see if I can. All right, so it's time to speak now about moving from climate change loss and damage to climate change justice, which means trying to protect the world's most vulnerable from the impacts and look at the Paris Agreement in that context. Now, so I want to talk just at the beginning of what I mean by climate change justice, achieving justice in human rights and addressing climate change. I've spoken and written a great deal about climate change justice. I had the honor to be co-chair of the International Bar Association task force that was inspired by Mary Robinson, the former president of Ireland, former UN High Commissioner for Refugees, now Special Advisor Ban Ki-moon on climate change. She challenged the International Bar Association. What is the world's largest international organization of lawyers going to do on this issue? So they established a task force. I was a co-chair. The other co-chair was Baroness Selina Kennedy, a very prominent human rights lawyer from England, who's also a member of the House of Lords. We put together an expert committee, and we wrote a report called Achieving Justice in Human Rights in an Era of Climate Disruption. And Mary Robinson thought it was pretty good. She said something good on the back, and so did John Knox, who was the UN independent expert on human rights and the environment, and Michael Gerard, who directs the climate change law school at Columbia University. But, so we wrote about it, we talked about it, but what dawned on me as I was getting ready to come here to Dhaka was, it's humbling to realize I'm here in ground zero for climate change, or at least one of the 10 most climate vulnerable nations on Earth. And, it's truly difficult for people from other countries, I think, particularly ones like Canada, the United States, where, the weather's a bit weird, but except for the Inuit in the north, in the far north, and some of our Aboriginal people in northern Canada who depend on ice roads in the winter for most of their transportation of goods, but the rest of us have not really experienced anything, I think, that's very mind-boggling about climate change. And in fact, I don't think most Canadians actually understand how serious an issue it really is. But your Prime Minister certainly knows how important it is. She wrote just after the Paris Agreement that I mean, each year the impact of climate change wipes out 2 to 3% of your country's gross domestic product. And so 900,000 Bangladeshis have died over the last 35 years because of severe storms and natural disasters attributable to global warming. And that by 2050, a predicted 1 to 3 foot rise in sea levels caused by global warming will submerge 17% of your country's landmass and affect 35 million people. Those are incredible statistics, incredibly awful statistics. Well, why did we start talking about climate justice? Well, because, in fact, what climate change does is more, I mean, Canadians might think of it in terms of polar bears not having ice to, go on, and they might have less ability to get food, but we also need to think about the human rights impact of climate change, and I'm sure many of you here are doing that. I mean, it started back in 2005 when Inuit people petitioned the Inter-American Commission on Human Rights to recognize damage to their human rights. And then, of course, there was the 2007 Malay Declaration on Human Dimensions of Global Change. And since then, the international community has been seeing a growing number of calls for recognition of the profound human rights impacts of climate change and to connect the dots. And of course, you know better than most people how human rights are being affected. I mean, it's going to fundamentally affect the right to life. It's going to, severe weather events from hurricanes and typhoons, heat waves and flash floods, you know, are causing massive loss of life. The right to the highest attainable standard of health is going to be affected. Damage to agriculture and accompanying decline in food security are far from the only threat. Climate change will result in exposure to countless illnesses, from cardiovascular disease to numerous vector-borne diseases that are temperature sensitive. Just look at the headlines in the last week about the Zika virus. That's climate change at work. This mosquito is now infiltrating from South America and different places, and even, I mean, the United States. That's when it gets publicity. But that's climate change-induced changes. It also, of course, contributes to forced migration and displacement. Some of you will know this, but an example is definitely Syria, where repeated hot summers contributed to droughts, which triggered hardships and riots that culminated in the vicious civil war. So what we're seeing in Europe with this migration issue is really, all the experts say, has serious climate change originations. And so that's just, this is a bad expression. It's the tip of the iceberg. We're not going to have icebergs around very much longer either. But I mean, Syria is just a tip of the iceberg in that sense, that it's just an unfortunately horrific but small example of what we're going to see ahead in terms of what climate change is going to do. I mean, it's also going to affect the free enjoyment of culture. When we presented this report in Tokyo, the annual meeting of the International Bar Association, we had Mary Robinson there, but I invited Mohammed Nasheed, who, as you know, was the president of the Maldives, and he spoke very eloquently, and he said, you know, climate change for us is not just rising sea levels. It means, you know, we're going to disappear. And it isn't just the land that's going to disappear. It's the people. It's the culture. It's the language. The whole culture is gone. And that's not just the Maldives. So it's a very serious issue. And it's going to impact minority rights. Women and other minorities will be set back considerably by the impact of climate change. Women who are caretakers in many developing nations have increased health risks and have higher mortality rates in the aftermath of natural disasters. Children face stunted growth and health problems due to malnutrition. And then we have to talk a bit about what happens to states as a result of this. I mean, I just mentioned the Maldives, for example. But many low-lying areas will disappear, not just Florida, parts of Florida, but you know, some very, I mean, your shoreline is, as you know, is poised to experience this. And that raises potential issues of citizenship. I mean, what is your citizenship when your country disappears? Do you have a right to claim citizenship in going to another country? Right now, our international conventions on on refugees certainly does not recognize anything like climate change as a factor that entitles you to claim to a state that you should be admitted. That's got to change. We are following up this report of the International Bar Association. We have two follow-up groups. One is a working group on climate justice and adaptation, and certainly the issue of migration and how to try and deal with that is something that we're going to be working on, and we hope to have a report on that by next July. So we said in our report there's a need for coordinated action above and beyond that which has been made to date under the UN Framework Convention on Climate Change to achieve climate justice. And really, fundamentally, this is the issue. The steadily growing threat of climate change lies both in the magnitude of the problem and in the disconnect between cause and consequence. Those who contribute most to the Earth's warming are often the ones most insulated from the full effects of their actions, geographically, temporally, and economically. And I have to think of Canada as being, at this point, one of those many countries who are somewhat insulated. And I think, my goodness, here am I in, a very affected country. So I'm taking it that much more seriously than I could ever have believed. So what do we do about this in a justice-speaking way? And I don't have time to get into that because I didn't. That's just to tell you, our report came out with an action matrix that lists actions that can be taken by many levels, by international bodies, by the World Trade Organization, by national governments, state governments, and I recommend it to you if you want to see the report. It's called, just Google Climate Change Justice International Bar Association. And it'll come up and you can download the report and its recommendations. But, for example, what we need to do basically is take measures to avoid worsening climate change and that means avoid continuing to emit enormous quantities of greenhouse gases. And secondly, insofar as development still is going to occur in developing countries, we have to not hinder that development in the methods we find to reduce those emissions. Just a couple of examples of what I mean. A group of experts in international law got together in March in Oslo, and they came up with some principles that they called the Oslo Principles, and just a couple of them. Reduce greenhouse gas emissions. Now, why do we need to do that? Well, unless we do that, and soon, we're going to be in major trouble. In 2012, the World Bank, working with the Potsdam Institute, came out, we're on a pathway to 3 to 4 degrees increase in global warming unless we actually act smarter. And as the World Bank and Potsdam Institute said, there is no certainty that adaptation to a 4-degree increase is possible. It's likely to be one in which communities, cities, and countries would experience severe disruptions, damage, and dislocation, with many of these risks spread unequally. It's likely that the poor will suffer most, and global community could become more fractured and unequal than today. And at the same time, the whole notion of the carbon budget came up. Because scientists, the International Panel on Climate Change, Intergovernmental Panel on Climate Change, the most eminent scientists in the world, who peer review everything else, have calculated that, if we're going to keep global warming within 2 degrees C, we can only emit a certain amount more. Unfortunately, for the last 150, 200 years, because of the Industrial Revolution, greenhouse gases have gone up in the air, and it's one of those things that does not dissipate and transform into something else. So it's still up there. And they calculated that we need to cap emissions below 1 trillion tonnes in order to avoid this problem. And some people have said we have to have a cap of 600 billion tonnes to really do what we want to do, perhaps to get to limit the increase to 1.5 degrees. Okay, so where are we now? Well, as of June 2014, we were at 580 billion of that 600 billion, or within, so you can see that we're well over the halfway mark, even if you take the limit at 1 trillion. And they calculated at current rates of a trillionth ton would be emitted in December 2040. I just clicked on the source of this called trillion-tonne.org, and there's a clock running all the time, and I think the figure as of today is 597 billion tonnes. So I mean, just in 2 years, it's almost approached 600. So we don't have a lot of time, and we have to refrain from starting new activities that cause excessive greenhouse gas emissions. And we should do something about embedded materials that are in the ground, but we'll come to that. So let me come now to the Paris Agreement, and will it be effective to prevent loss and damage? But I actually want to start with the question, will the Paris Agreement result in lowering emissions sufficiently in a timely way? Because if we don't keep emissions lower, then, you know what? We won't have any human rights left. We simply will be, you know, in a very stark and desperate society, and actually we won't be much of a society anywhere in the world. It'll be chaos. And this word climate chaos has been used, and unfortunately that will be the case unless we actually act a lot more responsibly. And in the context of Paris, it was very aspirational. Canada certainly supported the objective of limiting emissions such that they, of making sure that the temperature should not rise more than 1.5 or at least stay below 2 degrees. But Canada actually was one of the countries that got behind the aspirational goal that it should be only 1.5. But when you actually look at the Paris Agreement, you will see that there's no clear roadmap as to how that should be achieved. Basically, it's best efforts kind of process with potential reporting and, you know, international discussion, shaming to some extent if you don't meet it, but there's no clear mandate in a legal sense about how and when that would be achieved. So in the context of, you know, Paris was called, you know, we're going to have a new legal agreement on climate change. Well, the legal part of it is more that every 5 years we'll look at where we're at and revise our objectives. But there's nothing in there that says that any particular country or group of countries has to reduce emissions by X amount. And indeed, really what it says is that, and that's a problem, I think, because we're right now on a clear trajectory to a dangerous 3-degree sea warming of the globe. And, you know, that's a problem. There's nothing in it, in the current agreement, except to say that countries committed to a peaking of emissions, quote, as soon as possible, bracket with a recognition that it would take longer for developing countries, and a goal of net greenhouse gas neutrality in the second half of the century. Well, in the meantime, the agreement sets no emission limits that any country must meet. It simply encourages best efforts. So let's hope that the aspirations of Paris will actually work. And, you know, but I think what that means is there's a role and duty of individual state governments in lowering emissions, because it isn't going to happen. Now that we have an international aspiration, we now have to make sure that in each of our countries, particularly the ones that are the major emitters, we make sure that the emissions actually come down. And there is therefore a clear role for civil society, domestic courts, human rights tribunals, constitutional and human rights in limiting emissions. And, you know, otherwise it's going to be business as usual. You know, right after the Paris Agreement, there was a suggestion that it was going to be bad for the biggest loser in the Paris Agreement could be the fossil fuel industry, somebody wrote. But in fact, the Paris Agreement doesn't actually threaten them. Their interests are well protected. And in fact, the words oil, fossil fuels, and coal don't even appear in the agreement. Actually, I think these companies are celebrating the Paris Agreement. For example, in response to the Paris Agreement, the World Coal Association referred to projections by the International Energy Agency that, quote, electricity generation from coal would grow by 24% by 2040, even under the various emission target reductions just pledged by world states before the Paris meeting. So this optimism by the coal industry is consistent with some of the gaps in the agreement. For example, another thing it doesn't do is fails to mention, let alone endorse, the need to keep significant amounts of carbon reserves embedded in place as a vital step to meeting the world carbon budget. Now, in 2012, the International Energy Agency said, in order to meet the 2 degrees C target, 66% of proven reserves must remain embedded in place. Others estimated 80% of reserves must be unexploited to achieve safe levels of warming. There's no concept of that in the Paris Agreement. So, and then there's some things that, there are a number of things that are positive. I don't mean to, put the Paris Agreement under a big cloud. I'm just pointing out some what I think are significant issues that we all have to be aware of at a national level in order to keep our national governments, our state governments, our subnational governments, working at this diligently. So, is there a backup plan if governments don't do what they need to do at a national level? Well, here's where I want to start talking a bit about go back to this previous slide, the role and duty of individual state governments and the role of civil society. And so 2015 was not just the year of the Paris Agreement, but it was also marked the year where there were several landmark litigation decisions about duties of states to actually act on climate change. The first and most remarkable one was the Urgenda decision in Holland, taken by citizens, organized by a commercial lawyer who one day one of his colleagues said to him, "What are we going to do about climate change?" And the guy said, don't know much about it. And the other fellow said, "Well, go see the film, Al Gore's film." And so he did, and he got very, very inspired. And they organized, and he wrote a book. And the name of the book is called Revolution Justified, Why Only the Law Can Save Us. And his basic theory was governments have such a short-term mandate, they can't think more than 3 or 4 years in the future, and that's their priorities, and this is a problem that you have to, we do have to act in 3 or 4 years, but we have to also act in the long-term sense. So he thought, what can the courts do about it? And they took this case to the Hague Court on behalf of citizens and basically argued that the Dutch government had a duty in law to ensure that emissions from Holland were actually lowered by between 25 and 40%. Holland had been one of those Annex I countries that had agreed back at Cancun that they would cut back emissions by 25 to 40%, but that really didn't happen, but Holland had said they could do it. And so the case was put together, and what was unique about the case is it was based on the IPCC science, which in itself has emerged in the last few years to be very clear. So this lawyer put together a written argument to the court. It's a masterpiece of clarity. If you want to see the arguments about climate change and why it's dangerous, why it needs to be acted on now, and why there should be legal duties on governments to protect citizens, read the submission made to the Hague Court. It's online under the Urgenda website. And we joked in Toronto, we brought Roger Cox, the lawyer, into Toronto to talk about whether such a case could be brought in Canada. Some of us were concerned, at least under the former government, that not enough was being done. And so I think that has changed in the last few months. So it was very interesting. It was very interesting. We had a panel afterwards, a discussion. And one of the people who was listening to this was a just retired judge of our Ontario Court of Appeal. And he had the opportunity to read the brief and meet Roger Cox. And he was perplexed, and I think he was very shocked and surprised that he wasn't aware that this was such a significant problem that had to be acted on quickly. And somebody said, well, what can Canadian courts do in this situation? And the law professor who wrote the book on Canadian tort law, on civil wrongs, said, well, basically our Canadian courts would not act on the concept of negligence. There's too much discretion given to government in the court of whether government should be held liable for regulatory negligence. But then the retired judge's reaction was, well, if you brought this case to me, I would have gone for the Canadian Charter of Rights. I would say that, potentially this is a violation of the right to life, right to security of the person, and it maybe even could violate the right to not have discrimination based on age. What am I talking about? Well, it's, of course, that the young generations are going to suffer the most, and if we don't act to protect them today, they're going to be the ones that are going to be most implicated. So it was fascinating to see the reaction of someone like this, an intelligent person who was on the forefront of many issues, but didn't really know about the urgency of climate change until he actually had to read this decision and talk to Roger Cox. And it's kind of mind-boggling, and that's a concern, but it's also a revelation. Another case that is important that happened this year. So just to finish on you again, the Dutch government was ordered to cut emissions 25% by 2020. They have appealed the decision, but in the meantime, they said that they would conform. They want to clarify certain issues. Another decision was another important decision, and because I'm not going to. There's lots of details, and I am writing an article about all of this. But, let me just tell you about a couple of defenses that were rejected by the Dutch court, because I think these are defenses that most governments might offer. The first defense was, court, this is not for you. This is a political decision. How much we reduce is political. Court said, we don't agree. They said, they found that if the government has a duty to protect citizens from climate harm, which they found, then a court order to reduce emissions is consistent with preventing further illegality and is therefore a wholly appropriate remedy for a juridical body to issue, even if in the result it has political consequences. So here's what the court said, quote, the task of providing legal protection from government authorities, such as the state, preeminently belongs to the domain of a judge. The claim does not fall outside the scope of the court's domain. The claim essentially concerns legal protection and therefore requires a judicial review. This does not mean that allowing one or more components of the claim cannot have political consequences. However, that's inherent in the role of the court with respect to government authorities in a state under the rule of law. The possibility, and in this case even certainty, that the issue is also and mainly the subject of political decision-making is no reason for curbing the judge in his task and authority to settle disputes. Whether or not there's a political support base for the outcome is not relevant to the court's decision-making process. And the other defense that Holland, the government submitted is, well, Holland only contributes less than 0.5% of worldwide emissions, and judge ordering us to cut back, our industries to cut back, is not, in the overall scheme of things, going to make a big difference and does not deserve legal redress. But the court rejected that defense, finding it was legally invalid for the government to argue Dutch citizens had no legitimate interest sufficient to seek a court order for emission reductions, even if the percentage of Dutch emissions were on a world scale low. And so they took the basis that anyone who contributes to global warming, any state, should have that duty. If everybody said it won't make any difference, then there would be nobody liable. That's the argument of the oil companies. Don't you drive a car? You're contributing to global warming, so don't look at us. That's their tactic. Well, it doesn't work in court, thank goodness. At least it didn't work in court in this case, and it didn't work even in the U.S. Supreme Court when they wanted to regulate greenhouse gases under the U.S. Clean Air Act. That was also the argument, actually, of the Environmental Protection Agency. And when the Massachusetts took the government to court, and even the U.S. Supreme Court said no. They said that basically, they said reduction in domestic emissions would slow the pace of global emission increases no matter what happens elsewhere. So even they got it. So really what's happening is with the clear IPCC science, courts are beginning to get the idea that they can actually have a basis for doing something. It's one thing to try and sue company X for global warming happening in Bangladesh, but that maybe get you in all kinds of legal issues of causality and whatever. But it's another thing to be able to say, we know who controls emissions, it's governments. And so if governments have a role and a duty to protect citizens, then governments should have a legal obligation to actually act to control emissions. And that's what's happening. So let me tell you about the case in Pakistan, which is also fascinating. It was also decided this year, past year, the Leghari versus Federation of Pakistan, the Lahore High Court Green Bench decision. What happened here was a farmer, went to the High Court and said, look, Pakistan has a plan, a national climate change policy and a framework for implementation, fairly recent, 2012, 2014, but he said there's no progress on the ground. Now, this was mainly about adaptation, getting on with adaptation. And the judge, within 2 weeks of it landing on his docket, summoned senior officials from all branches of Pakistan's civilian government with responsibility for climate change to appear in front of him and basically said, tell me, ladies and gentlemen, what are your respective departments doing to act on this climate change plan? And after hearing from them for a whole day, basically he said, so I understand basically you're telling me you're not acting on this in any significant way, and one of the civil servants said, that's right, Your Honor. And basically, I think the rationale was, well, we have a plan, but it's not been, taken that seriously by all the government departments, and there's no real political will behind it. So the judge said, okay, I want to see you all back here in 2 weeks, and you're going to tell me what you're going to do, 3 concrete things that this government is going to do on the ground by the end of 2015. And by the way, the judge said, I'm appointing a commission, a judicial commission to supervise, and you'll be part of the commission, but there's going to be some outside people. The lawyer for Mr. Lahari was going to be on that commission and some other people, and they're going to report to me whenever I want them to report on what you're doing. And, and why did he do that? Well, he found climate change to be a challenge to fundamental rights that are protected under the Pakistan Constitution. And the eloquence of his remarks are quite stunning. He said, climate change is a defining challenge of our time and has led to dramatic alterations in our planet's climate system. For Pakistan, these climatic variations have primarily resulted in heavy floods and droughts, raising serious concerns regarding water and food security. On a legal and constitutional plane, this is a clarion call for the protection of fundamental rights of the citizens of Pakistan in particular. The vulnerable and weak segments of the society are unable to approach the court. He went on to talk about the fundamental rights in their constitution, like the right to life, the right to human dignity, and etc. And he basically said that we need, he said that, environmental protection has been a central focus, at many countries in the world, environmental protection. And courts have gotten on to that idea that we need to do more when the matters come in front of them. What this judge was saying, that we now have to, in effect, get into climate change, recognize climate change is a huge issue, and fundamental rights are being impacted. He said, as a constitutional court, it is a constitutional obligation to protect the fundamental rights of the people. Climate change has devastating impacts on the right to life, health, business, trade, movement, dignity, and property of the people. And then he had something to say about the government's attitude. I guess the chief secretary of the cabinet came in front of the court and said, we really don't have any direction to do anything at this point, and you court shouldn't do anything until the cabinet's made some decision. What did the judge say? He said that was a, quote, lackadaisical approach, unquote. Considering that climate change is a major national security threat, this lackadaisical approach is not appreciated. Climate change seriously impairs the fundamental rights of citizens. Therefore, the Secretary's Committee is directed to vigilantly take up and consider the progress made on behalf of the Ministry of Climate Change regarding the implementation of the national plan and framework on a monthly basis. So he basically told the cabinet, you've got to get at this and report to me on a monthly basis. And there's some other directions of that nature. And, courts will put these guys in jail for contempt if they don't act. So, sometimes governments need a judge to tell them, get on with it. And it was an interesting comment by an NGO person who wrote an article in the paper about this, who interviewed Judge Shaw. The article said, the judge's intention was not to put officials on the map, but to help them. Senior government officials had admitted in court to receiving no response from ministries to requests on what action they had taken to implement the government's own climate commitment. The judge noted that many were, quote, totally at sea, with no idea what was going on or what climate change was, and stressed the need for greater awareness raising and capacity building. And he characterized the cases having jump-started the government's climate change efforts at a time when they had been totally dead. So this writer said, basically, Using a human rights-centric approach invoking fundamental rights and constitutional duties, the judge had enforced within 1 month what others, including civil society and legislators, had failed to do for years. I mean, that's pretty significant. Now, there's been other cases, another case in California on this as well, but I won't get into that right now. So let me move then to the next aspect of this. How does a Paris Agreement actually help in terms of loss and damage? Well, first of all, what do we mean by climate-related loss and damage? And I mean, you all know what happens when sudden events happen, like cyclones, hurricanes, and sudden floods. But and those are types of loss and damage that, you know, to some extent you can possibly adapt to. You can build higher dikes. You can build safe places to go. You can have better weather forecasting. You can have better emergency responses. But then there's other types of harm to the gradual events, like rising sea levels or glacier melting that produces floods and then dries up rivers, or the influx of saline water into areas of farmland that wasn't present before, where these things take place over a period of time, and it doesn't appear that we have a method of actually mitigating that or adapting to that. That's just going to happen, and it's like island states disappearing. You're not going to be able to stop it. That's, you know, a dramatic example of slow onset of loss and damage. So we really need to, and up till now, up to Paris, the only thing that the developed countries wanted to talk about was how to respond to the sudden events. You know, I had a discussion with some senior official of one of the, I'll call them Western states. He said, you know, basically we don't want to talk about compensation for loss and damage or funding loss and damage for that other stuff, because the way it's been talked about for 20 years, it's been a sort of a liability concept. The original proposal about loss and damage had words in it that talked about the liability, not just responsibility, but liability potentially of developed countries who had caused all this to do something about it. And so basically most of the developed countries didn't want to talk about how to deal with it. So Paris was a breakthrough in the sense that because there's clear wording about that under the agreement, both kinds of loss and damage will be addressed, and funding and other mechanisms need to be established. But the quid pro quo was that in the decision document, they said, but this does not imply legal liability. Okay. But that's just a nice clarification that eases their task back home. They can say to their governments, well, we agreed we could help out on loss and damage, but it doesn't imply we have a legal obligation. And you know, that was a compromise that I think that the developing countries were put to make, and I think they saw that at this point it was probably not such a bad deal. I mean, some people may raise the issue about what does Section 52 of the agreement mean, but we could talk about that. But I mean, I think overall, if it in fact results in freeing up of funds from developed countries for developing countries on this issue, then perhaps it's probably overall a positive maneuver. And that doesn't mean that there still can't be some legal responsibility, I think, if somebody wants to go that route. So we talked a bit about the first bullet. We know that vulnerable communities and nations need funds to build resilience, or just to try and cope with the type of loss and damage that cannot be prevented. Some of that's already happening, as you know, and unless we're successful in cutting back carbon, we're going to have a lot more money because there's going to be a lot more loss and damage. Well, I was going to talk about this, but I think Dr. Huck has, to some extent, explained sort of the evolution of loss and damage up to the Paris Agreement. But let me say a couple words about what I've said already, a snapshot of, in a very high level, how it was approached in the past, the developed countries said no way, and basically if you're implying legal liability, I think that's going to be good. But taking responsibility for this is still consistent with international law principles. Let me see if I can find something here that I want to say on that. If you want to actually have a very good summary, short summary of the loss and damage provisions of the Paris Agreement, you can do well to read an article just written by Dr. Huck and Roger Mark D'Souza of the Wilson Institute in January, how loss and damage fared in the Paris Agreement, and I thought it was a really, excellent and easy to read summary. But clearly, what's now really neat about it, it says 8.1 of the Paris Agreement notes parties recognize the importance of averting, minimizing, and addressing loss and damage associated with the adverse effects of climate change, including extreme weather events and slow onset events, and the role of sustainable development in reducing the risk of loss and damage. And they said, 8.3, accordingly, areas of cooperation and facilitation to enhance understanding action and support may include early warning systems, that was on the table before, emergency preparedness, that was on the table before, slow onset events, that was never on the table before, events that may involve irreversible and permanent loss and damage, non-economic losses, well, that's pretty significant, cultural losses, many other types of harm and that you can't quantify readily. So you did really well. You did really well. And now we have to, the challenge now is to come up with innovative funding mechanisms to help alleviate the impacts of this loss and damage. And that's, I think, really our next challenge. And so let me turn for my last few minutes to some ideas about that. So we, it's lawyers like to look at precedent. They like to see what's happened before. And if governments are mainly composed of a lot of lawyers anyway, so it doesn't hurt to think like a lawyer in this context. So if we look back at legal precedents, we can find that there are a number of them that we can talk about in terms of this type of funding. I mean, one of the, and I'll just read you, if I could, about the international obligation on states, for example. First of all, we'll start with international law. There's an international obligation on states not to cause harm outside their jurisdiction. It's a fundamental principle of international environmental law, and it was set out in core documents such as the Stockholm and Rio Declarations and the International Court of Justice in its 1996 advisory opinion on nuclear tests confirmed the general obligation on states to ensure that activities subject to their jurisdiction or control respect the environment of other states and areas beyond national jurisdiction. And, even the UNFCCC Framework Convention talks about the individual state responsibility. It's not just collective responsibility under the UNFCCC, there's individual state responsibility, and particularly for Annex I countries to reduce their greenhouse gas emissions. There's a primary obligation. And there's a Canadian-American dispute, the Trail smelter case back from 1940-something or other, 35, where there was a smelter on the border, Canadian border, that was causing all kinds of damage across the American border, a bunch of farmers, and they weren't going to take it anymore. And finally, this got so hot and heated that it went to an international arbitration in front of the International Joint Commission. And they concluded that there was an obligation on the Canadian company and the Canadian government to do something. And they said, quote, "No state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another." Pretty fundamental, pretty apt, I think, for climate change. That marked a triumph of international law and diplomacy, and it's still part of our concepts. There's, let me just find my notes. Then another example, more recently, the UN Compensation Commission. After Iraq invaded Kuwait and lit all those oil wells on fire and created chaos and hell on earth, the UN Security Council said, Iraq, we find you liable for all this. You are going to pay reparations. You're going to pay compensation. You're going to establish a fund taken out of every barrel of oil that you pump out of the ground to help restore the environment. Well, there's a great example. And other people have talked about how not just states, but even the carbon industry has some potential responsibility for this. But there's other things. The Convention on Nuclear Damage, Civil Liability and Compensation is another one where it's a combination of private industry and states have taken responsibility for covering civil liability. And then the insurance industry is interested in this area. They develop programs. They need perhaps more development that take us to, I think, covering the catastrophic events. But I think insurance companies have a problem with slow onset events. It's not the kind of thing that they can calculate the actual aerial repeat time. Or, I mean, the closest thing that comes to slow onset events is somebody dying. Well, they do offer life insurance, but what they have a basis for calculating life expectancy and the probabilities, and so they can actually come up with, what is the risk, and therefore have a premium that reflected by the risk. But they can't do that with climate change. So they have not gotten into that. So there needs to be new innovative methods. One of the things we're working with ICCCAD on, I Institute CG, and we're working with the Wilson Center. We're organizing a workshop in Washington in the middle of March, and we're going to talk about innovative mechanisms for funding climate change loss and damage, both from an insurance perspective, from other financial perspectives, possibly from even a litigation motivation perspective. What do I mean by that? Well, one of the funds that exists, and it's a good example, is, and I don't know if I put it up on the screen, is the oil pollution cleanup funds. Back, some of you may remember Torrey Canyon, a big climate disaster, a big shipping disaster, fouled the beaches in England or France, and there was another one about the same time. Well, both England and France said, we're going to sue you guys, and basically there was heavy-duty litigation. Some of it was not successful, but the oil companies got the message. They said, we would rather, not be sued by all the countries in the world for, all the countries in the coastline of Europe for fouling their coastline. Let's see if we can't come up with some kind of a plan, a scheme, where we can contribute money, and people can claim for compensation based on a no-fault basis, and we'll contribute so much a ton for every pound of oil shipped. Well, this has been, and what did they get in return? They got in return a limitation on their civil liability, so a ceiling on how much they could be sued for. So they didn't get into that just because they thought it was a nice thing. They got into it because people were suing them. And so in the same way, the role of litigation will, I think, help get the message to carbon companies. And so there's been people working on such a project like the Climate Justice Institute who have developed a very interesting concept called the Carbon Majors Funding Loss and Damage. And I'll just take 2 more minutes. What's really interesting is that Richard Heed and the Union of Concerned Scientists came up with a report called the Carbon Majors Report, many of you have heard of, in 2013, established that 63% of carbon emissions in the atmosphere have come from the coal, oil, and gas extracted and cement manufactured by only 90 entities, the carbon majors, which of course include Chevron, ExxonMobil, Saudi Aramco, BP, Gazprom, and Shell. And of course, they've made a lot of money in doing that. Now, so this group argues that they should be invited to the party of helping fund loss and damage. Why? Well, first, poor people with little or no resources are suffering the worst, and their need is growing. Second, the current levels of climate finance are grossly inadequate. In Copenhagen, the world community pledged $100 billion annually by 2020, which is not being met. The poorest and most vulnerable countries need substantial and predictable levels of finance. Third, the fossil fuel business model does not take into account the cost of climate change. They've made massive profits from extracting and selling these things, yet the cost of their business practice, the impacts of climate change, are completely external to their business model. it's time it got internalized. So they think that these people should be invited to the table, and if they can't, they don't want to come sort of proactively, they'll be invited to litigation, and perhaps they'll see that it's in their long-term interest to get there. So litigation is also helping on the human rights front, and in regard to the private companies. In 2015, in the Philippines, a number of the victims of the climate change impacts that are happening there on almost a regular basis have filed a petition with the Philippines Human Rights Commission, and they're asking the Philippine Human Rights Commission to examine the role of these big corporate private companies that have contributed significantly to climate change, and the Philippines Human Rights Commission has accepted the petition, is now investigating it. And I know that some of the big American companies are nervous. They've hired the best lawyers, and they're going to see what they can do to sort of stay out of that mess from their perspective. Singapore enacted the 2014 Transboundary Haze Pollution Act, which allows them to implicate what's going on in Indonesia. There's a proposed Model Climate Compensation Act that you should know about, that I can tell you more about, that has just been released by Vanuatu Environmental Law and the West Coast Environmental Law. Basically would allow, if you change your legislation, as countries can do, you can actually, one country could sue people in another country or another country in their local courts. It's sometimes difficult, but you can change the law. And then the IBA itself, I'm co-chairing another thing, a working group that's looking at writing a model climate remedy statute, which will be out, we hope, in June or July, which will also facilitate litigation. Not that litigation is the be-all and end-all. It's certainly not, but it certainly has a role to play, and you can see what the judges think when they get a chance. They actually go with it. So, ladies and gentlemen, thank you so much for giving me the opportunity to speak to you tonight. It's my privilege to have done so, and I hope that some of the things I've said have been helpful or stimulating. Thank you.
Thank you.